Howdy and welcome to the Legal Hour with Bailey and Gallion. I'm your host Keith Spencer. We're coming to you from the Legal Cafe at Main Street and First in downtown Fort Worth, just across from the courthouse. And today I'm joined by Kim Smith. Kim is the managing attorney of the Workman's Comp division of the Bailey and Gallion law firm. Kim, welcome back in 12 years.
Yes, how time flies. I remember joining the firm in November 2013, and it's just flown by.
A wild ride.
Yeah.
Well, before we get into some of the new updates in Workman's Comp, why don't you tell us a little bit, just to remind everybody, how Workman's Comp works in Texas and what it really is?
Yes, of course. So, work comp coverage is not mandatory in the state of Texas. Employers can choose whether or not they carry workers' comp insurance or not for their employees. If they do not, they do open themselves up to a lawsuit, potentially. They can get sued by the injured employee if they sustain an injury on the job. But for the most part, I only assist injured workers that where their company does have workers' comp insurance.
All right. And some companies choose to self-insure.
Correct.
Famously, Walmart is so big.
Amazon.
They insure themselves.
Correct.
Okay. So, Kim, how do you determine if an employer has Workman's Comp coverage or not? I mean, if you get hurt, do they tell you?
Sometimes they do, sometimes they don't, Keith. So we go to the Texas Department of Insurance website and we can anonymously check, so there's no fear of, what if my employer knows I'm looking into this? We can look it up by the name of the employer and the date of the accident, so we're able to tell if they have work comp coverage. Also, we can contact TDI and ask them through an open records request. We can submit the information. Some employers aren't so open about whether they have it or not. They should all, if they have it, post it in the break room or wherever the employees might convene, so that it's posted on a wall there, who the insurance carrier is, the phone number, what to do in the event you get hurt. But some employers don't, and we've had to hunt down and go through DBAs and different address locations, and they're incorporated out of state before we find coverage. But we do look and we do confirm whether or not they have coverage, so that we can try to link the appropriate employer to the insurance, and then we can move forward with helping our client.
So that's the big poster you see in the employees' lounge or in the locker room, up on the big wall.
Yes.
And will that poster tell you we have?
It should tell you. There should be a space where the employer can write in who the insurance carrier is.
Okay, so you're working at a company, you know they have Workman's Comp, you get hurt, what's your next step?
Well, for sure, report your injury. And I know that sounds basic, but you would be surprised. And I get why you get 30 days, first off. So when you do get hurt, report your injury. Even if it might clear up tomorrow, you hope it clears up tomorrow. But surprisingly, Keith, I get people that, a week goes by, they hadn't said anything, they really don't want to cause any problems, they're trying to do right by their employer, and next thing you know, 30 days went by and now it's a problem. The doctor says you're going to need surgery, and now they go report it, and that's very problematic, because you have 30 days. You are required to report your claim to your employer within 30 days. Not a coworker, it needs to be someone in a supervisory position, but report your claim within 30 days. Even if you don't think it's going to be much, it's safer that it's documented versus having to come back and be like, well, I didn't think it was going to be a big deal. You don't know.
And you don't want it to get any bigger. Sometimes you're just a little sore that first day, and then you find out it's more. And the other thing is, sometimes getting in to see the doctor who's going to be able to tell you if you need surgery, it may take you more than 30 days to get in to see him.
Oh yeah, oh yeah.
Okay, so if I'm not sure I'm hurt, I'm thinking maybe it's going to work out, and I don't want to make a mountain out of a molehill. What's the best way to approach that with your employer?
So I get it. Like I said, you want to do good by the employer.
I'm no sissy.
Yes, and we have a lot of clients are like that. I get sore, I hurt all the time, but I'm not going to report everything.
Sure.
And I get it. Maybe you think that you'll be better the next day or in a few days or in 30 days, but again, What if it doesn't? And there's really no way to know. Just report it, even if it seems small, trivial. If it's enough for you to think, ouch, just report it. But don't report it to just anyone. It must be to a supervisor, like I said, or your boss, someone higher up than you are. You telling your coworker, hey, buddy, I think I hurt myself, and that's not notice. That is not considered notice. It must be someone higher up. I would suggest however you communicate with your higher ups. If it's a text, throw the text out, because then you have proof on your phone, or an email. But the verbal stuff, if it comes down to it being a denial, they will quickly deny your case if you didn't report it within 30 days.
It's going to be amazing how fast amnesia sets in.
Right. And it's a he said, she said.
I don't remember that.
So the employer shows up the hearing with the boss and 3 other people, and you're there by yourself with your representative, and you're having to prove to the judge that you told them, and they're saying, you didn't report it to us. If you did, we would have sent you to a doctor. Well, who's the judge going to believe? So text it. I wouldn't rely on a phone call. Email it somehow, some way.
A paper trail.
Paper trail, and make sure that they know something happened on a specific date and it's work related. And let me just tell you, it's not enough to say, oh, I hurt my hand yesterday. Well, nothing about that statement says it was at work. So
okay.
I hurt my hand at work while doing X, Y, and Z. So you saying, you know what, I'm going to go to the doctor tomorrow. I'll be in a little late. Nothing about that says it's work related. So I'm going to the doctor tomorrow because I hurt my wrist today, and I'm just going to get it checked out. I hurt myself at work. So be sure that 30-day reporting is you need to get that down.
Okay. So you get hurt, you report it,
Yep.
Hopefully leave a paper trail.
Yep.
Do all of that right. What happens next?
Okay, briefly, get seen by a doctor. Your company should, if they participate in a network, and this is a nutshell explanation, but most employers, it's going to be either a network claim or a non-network. And what network means is the insurance carrier that provides their workers' comp is in a network. So you got to go to those doctors.
The network doctor, kind of like your insurance.
Yes.
Okay.
Some employers' insurances are not in network, so then you could go see anybody that takes workers' comp. A lot of people think the first person I'm going to go see is my PCP. I will tell you, the majority of your private doctors where you go for your cold, they don't take workers' comp. And in fact, some of them have you sign things that as soon as you show up, this is not a workers' comp claim.
Oh,
so find a doctor that does workers' comp, but like I said, some insurance carriers are not in network, therefore you can see any doctor as long as they accept workers' comp. Mind you, again, this is a short explanation, but it's something we can definitely help find and answer and help you with when you call us.
Okay, so if someone gets hurt and they've got questions, are you open for some phone calls?
Oh, yeah, and just a little bit more on that first part. So money benefits are payable if you miss more than 7 days from work, and it's based on what your average weekly wage was. And a lot of people are like, well, how do they figure out how much I'm supposed to get paid under workers' comp? Think of it as a snapshot of the 13 weeks before you got hurt. That period of time, snapshot, gross wages, meaning no taxes have been taken out. So you divide that by 13, and that gives you what your average wage is for purposes of workers' comp. And right now, the max weekly rate is $1,271, and you can get that up to 104 weeks, which is about 2 years. There's a lot of nuances in that, but this is just right now the rate is $1,271. So, and if your doctor has you off work or they have you back to work with restrictions and your job can't find a job for you or any light duty for you, you should continue to receive your weekly check. So that's, and also during that 13-week snapshot period, it should include any overtime, bonuses, commissions, anything you might have earned during that period. So what I see a lot of employers do is they pay the straight 40, and that's not what your real wages were. It needs to be based on what your real wages were before the injury. So any overtime and everything, that all needs to be included. If at any time while you're receiving work comp, if they stop your health insurance, that will bump up what's your average weekly wage. It's called a non-pecuniary business. Benefit. So things like that, and a lot of people don't know to keep, follow up with that. So that's it in a nutshell as far as what to expect.
One thing about the practice of law, they call it the practice of law because it changes every doggone day. Okay, the legislatures are always busy stirring the pot, changing and tweaking things like that. And so recently we've had some changes in workman's comp, just as we have in all other areas of the law. And that's why really good attorneys like him go to special seminars that we have every year where all of the gurus in that field get together and say, what has the legislature and the courts done to us this year? What has changed? What's new? Now, you just recently came back from the annual Workman's Comp seminar, and I understand you're going to be speaking there next year, kind of helping out. So what have we learned?
So this year, this 22nd year, annual workers' comp, it's out of Austin. It's a 2-day seminar, and I was asked to speak this year, and my topic was on video conference for hearings. And so the hearings were by Zoom during the pandemic. There's 2 levels of hearings, the benefit review conference, and then you have the contested case hearing. The benefit review conference is an opportunity for all the parties to meet, discuss the case, come up with what the issues are, see if they can resolve it.
Right.
If they cannot, and I'll tell you mostly, it's usually we agree to disagree. Then we go up to the next level, which is in front of a judge. That's a contested case hearing. So since the pandemic, the BRCs have stayed Zoom. And just recently, with the 89th, the legislature, the bill, they allowed us to do contested case hearing now by Zoom.
So that's new.
That is new. Then that was actually my topic at the hearing, at the seminar, was video conferencing for the contested case hearing, the ones in front of a judge.
Okay.
So.
Well, Zoom is real controversial these days. So we were talking before we started today with AI and all of the new things that are happening in that area. Some people are questioning Zoom, or they're having to put some special safeguards in and that sort of thing. I will tell you, having done Zoom hearings myself in family law, don't wear your pajamas and sit in your easy chair, smoking a cigar while you're, quote, in court by Zoom, okay? We don't do that.
Right.
It will really, really hurt your credibility. Do injured workers have much of a choice between whether or not they're going to go by Zoom or whether they want to go down there in person and look that judge in the eye?
Yes, of course. So if parties are unable to reach an agreement at the BRC and they're looking for a date and a time for the contested case hearing, both parties, it requires both of them to agree to a Zoom hearing. So if claimant wants it by Zoom and the carrier does not, it's going to be in person. If claimant wants it, or vice versa. So if claimant wants it in person, it just takes one of them. If you want it in person, it's going to be in person, the old-fashioned way. So it requires both parties. It's kind of like both need to turn the key.
Right.
So they both need to agree for it to be by Zoom, and if they do, then it will be by Zoom. So,
as an attorney trying one of these cases, what are the pros and cons that you'd want your client to think about whether to go by Zoom or to dress up and come down to the courthouse in person?
Right. So with these are all administrative level hearings, and I will tell you, if you show up in person, it's an office setting. It is not a judge with a gavel and a robe and a jury. It is administrative law. So we're in an office setting. Basically, we're at our own desk. Insurance carriers at their desk. We face forward. Judge faces back. Kind of like a teacher-student scenario. And then, but first and foremost, it depends on the issues. So if it's a denied claim, I prefer to actually have my client there in person. I want the judge to see my client, present my client, and my client to be able to, answer the questions in front of him. I don't want that lost by video conference. Other issues that might arise in work comp, where what might be better or appropriate for Zoom, is if the issues are medical based. It's an accepted claim, and it's a medical issue, whether the knee includes a tear.
Okay.
So that really, my client isn't going to be able to testify to that. They're not an expert.
Right.
This is doctors, and usually the doctor's reports is what we enter in, and we just make our arguments. So that would probably be fine for Zoom. But again, it comes down to the injured worker, if it's convenient for them, if they're coming from afar and traveling in, or if they don't have transportation. But one thing you need to consider if you're going to do Zoom, it's got to be where you have connectivity and you have a place that you can do your hearing uninterrupted, no distractions or anything like that. So
I can't tell you how many people I have seen appearing
don't stay in your car.
in their car. In their car. I've never understood that. I can understand, however, that as an attorney, Zoom offers an opportunity for the attorney to help a lot more people in a lot more distant forums than they would be otherwise. I mean, for me to drive out to Amarillo or something like that is time consuming and difficult, whereas with Zoom we can be everywhere and we can help our clients, so we don't always get a choice where it's going to be heard.
Right, you're correct. So with the opening of Zoom video conferences, we normally had practiced DFW, Waco, Tyler, Houston, Denton. So now we can open it up to as far out as El Paso, down south to Weslaco, and Beaumont, and because these are places I usually would not go out on purpose. So now that it's by video, we can, it opens up the scope of our ability to help a lot more people. So.
Okay. What we're seeing today, the economy is a little bit rough for people. As a lot of people are trying to do it themselves. And there's, this is not just, I'm going to go fix the float on my toilet at home and I can Google it and figure out how to do it. But many, many cases are being tried down at the courts these days without attorneys. It's pro se, which is a $50 Latin phrase for I ain't got no lawyer, okay? Workman's comp seems to me to be one of those fields where it would be incredibly difficult to represent yourself.
So it's a very good question, comment. Yes, you can go to the TDI DWC website, read through it on the how-to, whens, whats, and try to navigate through that yourself. I will tell you, I have a hard time navigating that system. When I find the stuff that I'm looking for, I can't imagine being an injured worker having to go through what I did to find what I needed. You can try to do this on your own. Sure, can I, as a non-mechanic, go get the automobile manual for my car and try to fix it?
Right.
Sure, I can. Do I want to? I do not. Because with workers' comp, and at least with the car scenario, you could walk back your steps and fix it. In workers'
I've
comp,
always had to fix several things before I found the one that was actually broken. Yeah.
So your work comp case is important. It's not something you want to mess with. You don't want to make mistakes because some of those you cannot walk back. You can't untangle it. Once it's done, it's done. So the first time around, you want to get it right. So, there's things like late filings, not reporting, or not raising an issue. Those are things that, yes, you can do it yourself, but should you? I would say not. It's not something.
You only get one shot. Okay.
Yeah.
It's called res judicata. We've already tried that. You don't get a second bite at the apple. I tell folks a lot of times that it doesn't matter what field you're in. You get really specialized in any field, and you know things that other people don't know. When the court is considering a case, they don't have the opportunity to cut a pro se litigant extra slack. They have to treat them just like they would an attorney.
Right.
And so the other thing is the court can only accept admissible evidence. And it is something of an art form to turn your evidence into admissible evidence that the court can actually consider. And so if you do not have an experienced attorney helping you with your evidence, you're at a profound disadvantage, okay? And generally speaking, how does a workman's comp attorney get paid?
So we only get paid if the injured worker gets paid. So if you don't, and when I say injured worker gets paid, I mean if the workers' comp insurance carrier pays you money. It's not, if you're working and you're getting your paycheck like you normally do, we don't have anything to do with that. Right. It is only if the workers' comp insurance carrier you are receiving any kind of benefits that way. So a denied case, you're not getting paid. It literally, you're having to, you're getting 100% of nothing. So it's
Right.
costing you nothing. It only will generate, the fees will be generated, they act as a lien on the case, but only towards workers' comp money benefits.
So coming to see a lawyer to fix your case and handle that for you is kind of painless.
It's very painless, but like I said, the people that try to go out and do it on their own, there's cases that I can't untangle. I can't turn
sure.
it around. I can't fix the mistake. I can't. I mean, I try not. I let the people know what happened or where this probably went wrong. But if you wait too long, it becomes a problem. Or if you wait till there is a problem, it may not be a problem an attorney can fix.
A lot of times people will come in and talk to us about Social Security disability, and it seems like most people have tried to handle it themselves and gotten delayed and denied and denied, and they finally come in and see an attorney and they fix it like that. We can't always do that in cases outside of that area.
Right.
And if your case is already taken a poison pill, it's really, really hard to ever resurrect that case, isn't it?
Yeah.
So let's assume that after being warned, I'm still going to try and do this by myself. What kind of assistance will I get from either the court or the insurance company? Or
So as an injured worker, you're dealing with the adjuster and you're dealing with the Division of Workers' Comp. I will tell you, the adjuster is not there to help you. Let me say that one more time. The adjuster is not there to help you. If you take one thing away from today, two things: report your claim within 30 days, and the adjuster is not there to help you. Their insured is your employer. That is who they are taking care of, is the employer. That's their client. So the insurance attorney represents the insurance adjuster or the carrier who is there for you. Who is there for you? So think quickest, cheapest, bare minimum. That is what adjusters do. They get you back to work as quickly as possible. They spend the least amount of money on doing that, and they provide you the bare minimum of medical treatment. So I've had people, they crush their hand and it's a contusion.
Oh,
a contusion is a bruise.
right.
They're going to make you fight to include anything else after that bruise. They've accepted a claim, but it's a contusion. So the adjuster is not there to help you. And that's, you can go by the adjuster, but again, they don't represent you. They're not there to take care of you.
So if I'm hurt, when should I consider contacting counsel?
So we can speak to everyone and anyone that has been injured at work to see where their case is at. That costs nothing. It's a consultation. We'll ask you some questions. I will tell you, we don't need to know what happened the first day you got hired, getting it up to that. So allow us to ask you some questions and we can help pinpoint where you are and if anything needs to be done. I have told many, a new client, you don't need us yet, but when you get this, definitely give us a call. Mm-hmm. We try to help anyone that's having issues with their case. But unfortunately, like I said, we can't help everyone. Most of the cases that I have to turn away did try to do it on their own. And it's difficult to jump in when they're set to be in front of a judge in a month.
Right.
So that means this has been going on a while, and now you want an attorney, and it's just, we have to manage expectations, and that we can't turn things around. So usually the way I look at it is, by you hiring me, does that have any chance of changing the trajectory of your case? And if it doesn't, there's really not much I can do to help. Right. If we are unable to assist, the DWC, the division, has the Office of Injured Employee Counsel, OIC, and they do their best to assist a lot of injured workers, but let it be known that they let it be known at the get-go that they are not your attorney. They don't provide you legal advice. They cannot represent you. So they're there to kind of explain the process as you go along. And again, they're not there to represent you. Okay. So things to keep in mind.
All right. Is there anything else you want to remind folks of as they consider their options or their family members' options when someone gets hurt?
Yes. So if your claim is denied, seek legal representation. You will have to go to a hearing. There is no resolving that without a hearing. You're not getting paid. Treatment may be non-existent because and medical bills are piling up because their claim's denied. A doctor's not going to see you for free. They want to make sure they're getting paid. Let us see what's going on with the case and get your ducks in a row so we can get you to a hearing. We do try to get people to a hearing as quickly as possible once we have the information. But as you said, Keith, you get one shot at this. So if you're like, well, Kim, I want a hearing tomorrow. Well, if I don't think it's ready for a hearing, we're not going tomorrow because you'll lose. If you want to go lose tomorrow, that's on you. But
Right.
let us get everything together and then we proceed forward. But I do ensure you that we do it as quickly and as efficiently as possible.
If someone offers the employee rather, a document to sign while they're at the hospital getting stitched up, you have any thoughts about that?
Yeah, I would not do that.
It happens.
Yeah, especially because you're, and a lot of people want to do right by the employer.
Sure.
I want to, because they've been good to me. Well, you provide them work and they pay you. So that's what is expected. That shouldn't be considered they're being good to me.
And it's not always your employer, the good guy, who's trying to get you to sign that piece of paper that says all we owe you is for your car.
Right.
You know,
Right.
whatever it is. Okay.
Right. I would not recommend signing anything. They can wait. They can wait till you get out of the hospital. They can wait. Just ask for a copy. Can I have a copy of it?
They could wait till you're off the painkillers too.
Right.
Okay, so just a thought. Kim, how should people get into touch with you?
Just give us a call here at Bailey & Gallion. We have our website. We have 24/7. They can answer any. They'll get you to our department. And again, like I said, we have some questions we just need to ask you to determine whether we can assist you. And if we can't assist you, we'll at least provide you information of where to go and what you might want to do next. So,
All right. That'll do us for today. Thank you again, Kim. This is
Welcome.
Kim Smith. She's the managing attorney for the Bailey & Gallion Workman's Comp Department. And if you have any questions, I know she'd enjoy taking your call. We'll see you soon.